Order, would you please join me in the pledge? I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So this is a continuation to discuss a complaint against an employee, and Paul, my understanding is you want to continue this in open session?
Yes, that is correct, and I do
Okay.
have a statement from my attorney that I would like to read. It's much shorter than the statement from last meeting. Just 2
Let me
pages.
just gauge the board on order here, so. Does the board want to say anything before we have? Do you have no? Okay, go ahead, Paul.
Thank you.
Thank you.
I'll read the correspondence. It's dated today, October 12th. It's addressed to the Select Board. My name is John Clifford, and I've been retained by Paul Cohen, the town manager. The Select Board has convened a meeting to consider charges or allegations against Mr. Cohen based on the findings of a Department of Labor Relations hearing officer in the matter of MUP 19-7227, 7313, and 7361. Prior to making any determinations against Mr. Cohen, I would like to call the board's attention to a number of relevant facts. The prohibited practice charges that are at the heart of this controversy center around alleged unlawful ex parte communications between counsel for the town of Chelmsford and a volunteer management representative for the Joint Labor Management Committee, JLMC. Prior to going into private practice in 2007, I served as a management representative on the JLMC, including 2 years as management vice chair. Since 2007, I have represented many municipalities before the JLMC. During my 25 years of involvement with the JLMC, there has never been any official or unofficial rule, policy, or regulation prohibiting communication between appointed members of the JLMC and those they represent. That applies to communication between management representatives and the city or town, as well as to police and fire union representatives and the local unions they represent. There is no prohibition against cities or towns communicating with their JLMC representatives throughout the JLMC process. The JLMC is comprised of management representatives, fire union representatives, and police union representatives. Over 90% of the cases filed with the JLMC are settled through mediation. During mediation, the management, police, and fire members serve as advocates for either the town or the union. Neither management nor union members of the JLMC are neutral. All through the mediation process, those members receive confidential communication from their constituents. If, as was the case in Chelmsford, the process moves to arbitration, the union representative and the town representative continue to act as advocates. The idea that these advocates would magically transform themselves to completely unbiased neutrals during the arbitration process is nonsensical. There is only one unbiased person on the JLMC arbitration panel, and that person is specifically identified as the neutral chairperson in the JLMC rules. If there was any rule or limitation on a JLMC member communicating with the party they represent, be it in a town or a fire or police union, there would be a rule against it. I have served as JLMC management representative for 10 years. During my entire tenure, I advocated aggressively for the city or town, and my police and fire counterparts aggressively advocated for local unions. That advocacy did not stop when arbitration process began, as the DLR decision suggests. The JLMC has been in existence for more than 30 years and has lawfully promulgated detailed rules governing their operation. If the JLMC had not seen fit to create a rule prohibiting communication with parties during interest arbitration, the Department of Labor Relations should not create such a rule for them. During the JLMC process, the police sergeants union, the town was represented by a highly capable and respected labor attorney. The town's attorney had no reason to believe that communicating directly with the JLMC management representative was improper because there was no rule against such conduct. Mr. Cohen had no reason to question this strategy being employed by the town's attorney, and imposing discipline against Mr. Cohen under these circumstances would be completely inappropriate. The hearing officer's decision contains no specific factual finding that Mr. Cohen took any action that was unlawful, or that he engaged in any conduct that violated the town's duty to bargain in good faith. As a matter of law, Mr. Cohen could have delayed presentation of the JLMC award until the next town meeting, delaying a vote on funding potentially until the following spring. Had he done so, it would likely have increased the likelihood that the town meeting would vote against the award. The union's allegations that Mr. Cohen only presented the dissenting opinion to the Finance Committee and the town meeting were ultimately proven false. The ultimate finding that Mr. Cohen of the town failed to bargain in good faith by failing to tell town meeting of the unlawful ex parte communication is absurd, given the fact that there is no prohibition against such conduct. I am respectfully suggesting that there is no basis for the Select Board to take action against Mr. Cohen because of the recent decision from the DLR. Any contemplated discipline would need to be predicated on Mr. Cohen having violated rules or standards that simply don't exist. The DLR couldn't find or articulate such a rule on ex parte communication, and 2 years after this dispute began, the JLMC still doesn't have any such rule. It is a fundamental principle of labor employment law that there must be clearly articulated rules and that those rules be uniformly applied. To the degree that representatives of any union may be pressing board members to take disciplinary action against Mr. Cohen, you should ask how that person's union would respond to a member being disciplined for violating a rule that doesn't exist. Mr. Cohen represents the Select Board in the town in negotiations with labor unions. It is his duty to negotiate fair and responsible collective bargaining agreements. But at all times, he is representing the interests of Chelmsford and its taxpayers. On February 4th, 2019, the town received a JLMC award that included wage increases for the Police Superior Officers Union. That very night, the award, including a management dissent, was presented to the Finance Committee and town meeting. The award dissent simply stated that the wage increases in the award were more than the increases negotiated with other unions. The chairman of the Finance Committee passed along that information to the body and town meeting, voted to reject the award. That was their lawful prerogative. It is notable that the DLR decision does not state that any information in the dissent was incorrect or misleading, nor did the chairman of the Finance Committee say anything that was inaccurate. The DLR decision in this matter resulted in the lawful vote of town meeting being overturned because of a rule that simply doesn't exist. The rejection of the award led to 2 years of litigation at the DLR, but Mr. Cohen did not engage in any unlawful, improper, or misleading conduct that caused town meeting to reject the award. Mr. Cohen had no reason or motivation to break the law with regard to this matter, and he did not do so. He properly deferred to the experienced attorney appointed by the Select Board to represent the town before the JLMC. If a highly reputable and experienced attorney had no knowledge of the purported rule against ex parte communication, there is no basis for the Select Board to hold Mr. Cohen responsible for violating that rule. Over his career in Chelmsford, Mr. Cohen has represented the town during labor negotiations in a professional and successful, respectful manner. He has an outstanding record of treating Chelmsford unions fairly and courteously, and this DLR decision should not detract from that record. I respectfully request that the Select Board find Mr. Cohen did nothing improper and take no action regarding this matter. Regards, John J. Clifford, Clifford & Kenny, LLP. Thank you.
Thank you, Paul. So, Joe, when we last left off, I think you had suggested more definition around the specific complaints.
Yeah, I think.
Would that be a reasonable place to go now?
Yeah, I think what I had said is that to the extent that this was sort of a two-part process, the initial process is for the board to have a discussion as to whether or not it believes, a majority believes, there's reason to hold or schedule a disciplinary hearing for Mr. Cohen, and if the answer to that is yes, that there is, then the board would need to put some definition as to what it is that we're going forward on a disciplinary hearing on. So I think that's where effectively we left off. I'm not sure that a majority had decided as of yet that a disciplinary hearing needed to be scheduled just yet. So I think that's sort of step one. If a majority determines that a disciplinary hearing should go forward, then the board members that I guess are pursuing that would need to identify, in general terms, not, doesn't have to get down to the specific wording, but just conceptually, what are the areas or the actions or inactions of Mr. Cohen that the board feels is warranting a disciplinary hearing to be held.
Thank you. So I guess I would put it out to
So,
George
I mean-
and Ken, because you,
and that's fine. Paul, you've read two statements, and there's been a lot said by the public, and we haven't really addressed in our open meetings and so forth. So I wanted to start with just a couple notes to comments that have been made and thrown around over the last, since this decision came out and so forth. So that, this whole case and so forth, the issues with the sergeants has been here for 6 years, right? And that was right when I took office. So my entire 6 years, this has sort of been hanging over, all of our heads. And from my first meeting with the Board of Selectmen, I had to recuse myself from the entire process. So as far as accusations that, the board knew what was going on, was told what was going on, in comments made last night, that's not necessarily the case. I was recused. Mark wasn't here. Virginia, you were in your first year.
I wasn't here.
She wasn't here in the beginning, and then as you came into it, so this matter was not decided wholly by this board, as was inferred, last night. And secondly, I do want to say the comments that were made about the police department. The Sergeant Good never once has approached my son and had a discussion about this with him. My son has never once brought this up to Sergeant Good. There has been no pressure put on my son about this. In talking with Chief Spinney, he says Sergeant Good's an excellent officer. He does a great job. He definitely keeps this totally separate from his job. So, when I look at all of that, and then I go and I look at the town manager's job. The town manager's job is to really the taxpayers of this town and the residents. And his job is to keep, primarily the biggest complaint we get is about taxes, and the job is to keep that tax down. So in reality, no union should like their town manager. And I get that. And that to me is fair and understandable. If you had a bunch of unions saying we love our town manager, we'd have to question what kind of job is he doing in his contract negotiations. And Paul, you've done a great job negotiating those contracts in the past. And I made the comment, I don't necessarily know if everybody agrees with it, but if you do a wonderful job, our unions fall out of parity with the unions in other towns, because then they start to get underpaid if you're really good, which I think in some cases we do see that. So you've done a really good job negotiating our contracts. So, I've given all of this over the last 6 years a lot of thought and wondered what was going on and curious as to find out why and what happened. And now all of a sudden the opinion comes out and I, in prior, over the months as testimony was going on, I was emailed copies of the testimony. I never opened them. I was emailed documents that, all sides wanted me to look at. I said, nope, not until this is done. I'm not doing that. Even Paul, you tried to update me a few times on what was going on. I even said to you, don't share with me what's going on. I don't want to know. And so this all came out at once, and you can see the size of Virginia's book. That's all the testimony that had to be read. This is the DLR case had to be gone through. So it's a lot of data to get dumped on you and to go through while you have a full-time job in a 6-week period. So, I did go through, and I have read a lot of the testimony. I read the DLR case, and I did go through and make some points as we look at all this. And as I read the testimony, Paul, even you questioned in your testimony whether this was the right process. That you were asked, and you asked Mark Terry, are we supposed to be doing it this way? So even you had concerns about the way this was being done. And that came out in the testimony. So I see that, and the rest of it, I think, did you bargain in good faith at town meeting? I think you did. I don't see an issue there. You know, I think you followed the letter of the law right up to the end. So what I come down to is, should you have known, or should you not have known, that your communications between you, the town manager in Andover, and Mark Terry were inappropriate or appropriate? And as I look, again, through the testimony, and I read through that, you know, it seems to me at first there was no interaction with you and Andrew Flanagan. And then in the testimony, it came, and believe me, if I was in the seat, I'd probably do the same thing. It came out that, well, there was a meeting after one of the hearing briefs with you and all the people involved. So you did meet them. And then there was maybe an email or two. And then I see a text message that says, oh, well, if you have problems, Mark Terry to Andrew Flanagan, reach out to Paul directly. Well, how's Paul doing? Well, clearly there's a level of friendliness there that I see in the text messages. If they're asking about personally how you doing, how you holding up, type of things. So I look at it like the rules on the JLMC might be wishy-washy, but this happens all the time, and we've seen it throughout history. When the rules aren't clear, the line gets walked out, and at some point you have to say, enough. Now, do I think this is a horrific offense? No. Do I think you were even questioning it yourself? I do. You know, you also serve on the policy committee on personnel and labor management for the MMA, which, you know, I think there's lots of topics that are covered there. You know, you sit on a lot of boards. I think in your mind you knew that this was an uncomfortable area. When the dissenting opinion was drafted, you know, by the attorney, you even questioned, why is he doing this and why isn't Flanagan? So there was a level of, I'm not sure what's going on here. I don't understand why it's going on. And I come into a pickle there. Like, well, if I was sitting in your shoes and I had an attorney telling me this and I was in this deliberation, what would I do? Would I step on the brakes? Would I allow it to keep pushing through me? I think a weaker personality would say, yeah, let this thing just go. In my 6 years, Paul, you're not a weak personality. You're a strong person. You're a strong character. You're a smart man. Like, probably you are, I mean, even your education tells us how smart you are. I've watched you work wonders with numbers and sat back and said, wow, that was impressive, you know? So I can't chalk it up to the fact, especially with the testimony and everything else, that you didn't know what you're doing was walking a line. But again, because there's no rules against it, part of me will question, like, well, what does that mean for punishment? You know, I don't know, but I do think, you know, me having not been part of the entire process all this time, seeing all this data now as it came out, if I had been in those meetings, I think I would have said, whoa, what are we doing here? This is confidential emails we're getting. They were emails sent out by the head of the board to the two members, stamped sensitive and confidential, that were then forwarded. I think I would have said, what, you know, is this right? Is it legal? And when we read the testimony from Attorney Terry, he even said, yeah, I can remember maybe one other time of doing this. You had just gone through the firefighters union and none of this took place. So I think there's enough there to say we crossed a line that maybe shouldn't have been crossed. But for what the penalty for that is, I'm not sure. So if someone would ask me, what's the charge? Or what do I want to investigate or continue to the hearing? I mean, I feel that if the evidence is there to show that Paul knew that what was going on was questionable at best and maybe not right at most, and if the claim is, I didn't know, I'm innocent, well, then you should have known, because of the boards you sit on, and you've been doing this for 30 years, you've been through the JLMC, it had never happened before, and that's where I'm at.
Thank you. George?
Okay, well, I think this is something that has to be done, good, bad, or indifferent. We have to come to a final decision, and we have to get all the information out. Whether we win or lose, I mean, we owe it to the town, and we owe it to ourselves, and we owe it to Paul to get all the facts out there the best we can, and then come to a decision. So what I did was I just read it a few more times, and I just write it, that the DLA has ruled. They ruled against our town and against our town manager. I did some background checking on the lady that was, in charge of this thing, and even Attorney Mazur said that, you could never appeal her stuff, when they'd never overturn her appeal, so apparently she's very qualified. But, so, these findings by the DLI find that the town manager did not act in good faith and failed to bargain in good faith. Again, that's her opinion, that's her decision. He participated in ex-party communications. The hearing officer ruled that he was well aware of all the communications between Attorney Terry and Andrew Flanagan, particularly those marked confidential, page 34. He participated in the unlawful writing and submission of dissenting opinion, which he knew would be incorporated into the award. Whether he participated or not, I don't know, but at least probably was told what it was and gave permission to do it, potentially. These are things why we're doing this. We're going to find all this stuff out. He failed to tell the Finance Committee at the town meeting that dissent had been authored by the town's attorney and not one of the actual arbitrators. He blocked us from using Attorney Brian Harrington's final report to the Select Board after his investigation, which the town paid $9,000 for. The taxpayers who paid for this deserve to hear and see it. Finance Committee Chair Clancy testified Town Manager Cohen's failure to reveal to Finance Committee and town meeting that the town authored and the dissenting opinion and that the town manager paid for it and pre-approved it was significant omission in the town manager's presentation. Clancy also testified having that information would have certainly affected his vote as both as a Finance Committee member and a town meeting representative. Ordered by the consequently some of the orders by the Department of Labor Relations. Town must cease and desist from failing to bargain in good faith by engaging in unlawful ex parte communications with the intent to gain an unfair advantage or influence and modify an arbitration award. Town must cease and desist from misleading the Finance Committee and the town meeting when considering a funding request. Town must cease and desist failing to provide relevant information to the union to provide its duties as a collective bargaining representative. For years, we have been told by the town manager that there has been no determination as of yet. We now have a determination. The decision was issued by a well-respected, experienced attorney, hearing officer, who is employed by the Massachusetts Department of Labor Relations, specialized in Massachusetts labor law. This hearing officer heard 8 days of testimony and saw all of the evidence in this case. Her ruling cited legal precedent and case law. This is not just one person's opinion, as some have tried to argue. Town Manager Cohen has cost the taxpayers over $270,000 in expenses and legal costs on this matter, and were unable to produce a single witness who would testify during the hearing that the town's behavior was not improper. Yet he chose to go forward litigating this case instead of owning the behavior that they knew no one would say it was proper and with the business as usual. Testimony and evidence show that all of the involved parties were hiding all of the improper, illegal behavior from the neutral arbitrator and labor side. Town Manager Cohen has continued to downplay his role in the ex parte communications, but testimony by him and others revealed he was involved in an in-person meeting in his office with Attorney Terry and Andrew Flanagan, where confidential information was revealed by Flanagan to both of them. Town Manager Cohen chose to speak on his behalf during a meeting last week. A careful review of his comments shows that he was very selective about portions of testimony and executive session minutes he chose to use, many times cherry-picking only portions that thought he made his argument while leaving out mischaracterizations of other parts that didn't fit this argument. For these reasons, I believe at least a disciplinary hearing is warranted. Thank you.
Thank you, George. Anyone else?
Yeah, I mean, I didn't realize that we were coming here with each individual statements. I just have a couple of notes that I've made from reviewing the the documents. We've talked many times about how there are no rules and regulations really regarding, it seems, regarding the conduct of the committee members on a JLMC, I guess except for the arbitrator. And I think, as Attorney Fair pointed out at our last meeting, the union and the management representatives are not really considered arbitrators. They are just members that help decide the case. And the committee members are required to assist the respective parties. Well, how can you assist somebody if you don't talk to them? So I think the communication has to continue. And as far as confidential emails and things like that, I mean, we're forwarded sometimes confidential emails, and confidentiality is, it has different levels. I can't see how something has to be so confidential, depending on what the level of it is, that the various parties may not share that with some other people that would be relevant to the discussion. On page 10 of the decision, it even suggested a meeting with the parties in order to try to resolve the case before it finished arbitration. It sounds like the panel has the discretion on how much communication to have and how much discretion to have. It's to try to effectuate a settlement. So it just seems like the process itself does have flaws, and we've talked about that before. And as far as Paul not standing up to Mark Terry and saying, this is wrong, you can't do this, I think we all that were on the board at that time, and yet some of you weren't, we listened to what he said and took what he said to heart. I mean, it sounded to us like he didn't do this just one other time, that he had done this many times, that this was his common practice to continue the communication right up until an arbitration award was finalized. As far as drafting the dissent, Andrew Flanagan could have modified it any way he wanted to. Obviously, he felt comfortable with what Mark Terry had given him and signed his name to it, at which point he owned it. So I do not see anything rising to the level of a disciplinary hearing. In the decision, it does say what we can't do anymore, and we just can't do those things anymore.
So Pat, I haven't gotten through the executive minutes yet and reading those. So are you saying that when Mark Terry came in and gave you updates as a board, he specifically said to you he was working with Andrew Flanagan with strategies, discussing them back and forth between him, sharing it with Paul?
Not before not during that time when he was doing it, but after the fact, he said this was not uncommon for him to do this. He didn't go into that.
Okay, so you
much
didn't give him
detail.
permission up front. It was an after the fact, this is what I did.
We didn't give who permission to do
Like you
what?
didn't, well.
We didn't give Andrew.
No, don't get angry. What I'm asking is, the accusation was made that the board knew this was going on, was allowing it to happen, but that's not necessarily the truth. What happened is it happened, and then when you were given an update on it.
Correct, yeah.
Yeah,
Yeah.
so it wasn't like the board sat back and said, go get him, chief, and had your consent and,
I think the board encouraged continued discussion and negotiation to try to resolve this before it came to the arbitration.
right,
But
in
as
those
far
words
as-
and at that
As far
level.
as how to do it, I mean, that's what they're paid for, to determine how that's to be done.
All right, so I just want to be clear. It wasn't like you guys knew exactly what he was doing and what conversations were taking place. It was more of a, after the fact, this is what we did.
I guess you could say it that way, yeah.
Well, I did. Okay.
One of the things I noticed in the minutes was it was March 11th of 2019, which was after the February town meeting, and after the effort in January and February to write the dissenting opinion. There was a statement in those minutes that said Mark Terry disclosed that he wrote the dissenting opinion. So that was just an indication
You
to
didn't
me
know he
that
wrote
you
it.
that
Correct.
you
We did not.
you were not, the board may not necessarily have been exposed to all the details of
Right, and I
how
don't
it
think
was
we
going
thought
on.
that was unusual at that time. I mean, I I didn't jump up and say, well, you shouldn't have done that. Because, as I said, he indicated he had done this many times before, that it was pretty much common practice for him to do that. And if that brings a resolution, then, you know, he was working for the town, and that was how he felt he could best serve the town in this situation.
If we find that Mr. Terry may have done something wrong, do we have the ability to bring some kind of charges against him as opposed to?
I mean, the select board doesn't have any, I guess, authority over,
I guess we don't have any authority over anybody. We get blamed for everything and make all kinds of enemies, and we just sit here and take it, I guess. Is that what we're supposed to do?
I'm not sure what, about that piece of it. I guess the question I'm being asked about Attorney Terry is that the board has no real authority over Mr. Terry, so I'm really not sure what
Who does have
action
the
you could
authority over Mr. Terry?
in what regard, Mr. Dixon?
Well, he's hired by us.
But my understanding is he doesn't work for the town anymore. So I guess if that's your authority, then that's your authority, and you've already exercised that authority at this point.
If you, at that time, you're still working for us, we were still paying him to represent us, is that correct?
I think what George is asking, can you go after an attorney for bad advice?
Or
That's-
bad actions, if that, in fact,
That's the
they
question.
turned out to
Right,
be.
exactly. I mean, that's questionable whether it, I mean, I think even Attorney Fair, you know, agrees that what he did may or may not be right, and it's debatable.
I mean, somebody could pay the $300,000 that the taxpayers gotta pay for, you know,
You keep raising that number, George.
well, whatever it is.
Inflation.
It's actually less, isn't it?
270?
Whatever. I'm just asking a question, sir.
I'm not sure what the question is, Mr. Dixon, though. That's what
I can understand that. Thank you.
I think his question was, can you go after an attorney for bad advice? I don't think you can. But
I mean,
I mean, if he did that on his own, without asking anybody and get any okay from anybody,
the
and it wasn't the proper thing to do,
the question is, so generically speaking, you know, attorneys, if someone were to have engaged in some sort of a, you know, legal malpractice, there's always that ability. But particular to this case, well, one, I'm not completely versed, other than reading the decision, as to what exactly happened and whatnot. I haven't analyzed it from a legal malpractice standing, but it would seem to me that it'd be very difficult to show that that's legal malpractice in a situation where, quite frankly, the rules of the JLMC are undefined when it comes to certain things. So, and then you'd have to show where the legal advice sort of resulted in something particular where there was a loss. There was litigation, there was a finding against the town at this point, but it's not entirely clear to me, based on the law, because it is a case of first impression, as to whether or not the conclusions reached by the DLR hearing officer would withstand challenge on appeal, given that the rules are pretty undefined in my experience at the JLMC. So, to answer your particular question about this particular case with this particular attorney, it's impossible for me to do so based on the information that I have, but theoretically, you know, anytime a client is unhappy with an attorney, there's avenues to pursue, but I'm not sure that those would apply here.
could you check on that in case we do go a little further with this? I mean,
Well, that would-
or is that something that's just
I think-
irrelevant?
Well, that would be something that's up to the board. I don't have that authority to sort of act on my own, and, you know, or on the basis of one
I'm not
member's
sure that's in the
request.
scope of this meeting
I would agree.
to decide. I mean, we'd have to
Well, I
probably
mean,
have
if somebody
another
else is getting blamed for something that somebody else did, That's all I'm asking. Whatever, no problem.
Mark?
Yeah, I didn't come with a prepared statement either, and to Ken's point, no, I wasn't here during any parts of this, so what's been left behind is what I've had to read, and there's the book over there in the regulations, the JLMC policy, and I've taken a look at some of the publications that the hearing officer had cited. It seems to me from everything I've read that the JLMC's policy, written, unwritten, is certainly to try to get a negotiated settlement between the parties and try to do that without having to come down to make a final decision. So to me, they're trying to constantly communicate, negotiate any way they can so that the two parties settle without them having to make a decision. I think that's a good policy. Their policy is also not to really have a lot of black and white rules. And so when I went back and I looked at this arbitration, these two documents or trade publications really that were cited, I see no connectivity between those publications and the JLMC process, which is exactly what we're discussing. I mean, that's what this is all about. It's about the JLMC process. So when I see many different attorneys all reference their experiences in JLMC cases, and the majority at least saying that, you know, it really runs differently for every individual case, and there seems to be a lot of communication, I just don't see how suddenly we're going to hold somebody that is like 3 degrees of separation from that process as being the person responsible. I mean, I look at the charter says, Paul, the town manager is responsible for negotiations. I don't think he's responsible for the JLMC process once they take over, over control over the proceedings. And, you know, once they do take over control, I think it leaves him, and it's between Flanagan, Terry, and then he's number 3. So, and I also don't think, when I read through everything, and I'm not trying to split hairs with meeting minutes and what this or that said, I don't think there was anything new once they got to arbitration. I don't think there was a lot of new material there that could be discussed that had a lot of bearing on the final decision. I mean, they went back and looked at the MOA, you know, that which occurred way before the arbitration and mediation process even started. So I don't think there's any secrets that Terry understood all the salient points that were being negotiated. I think Flanagan intrinsically knows what they are. Flanagan had been involved before with 2 other mediation arbitration cases with the town. So I think he kind of has a good background there. So I'm just really having trouble going down 3 tiers to try to say, Paul, why didn't you know, about these 2 trade publications that have no connectivity to the JLMC process? I mean, I think it's absurd to think that. I mean, I've spent my entire career in regulated industry, whether it was domestic law and how that relates to regulations and how that relates to policy, or international law the same way. And you can't suddenly just grab something with no connectivity and suddenly apply that against, somebody's individual responsibilities that are very broad from the standpoint of negotiations for the town. I just don't see how we can do that. So, and again, I'm not trying to split hairs with, I don't think this has to do with how much somebody paid in attorney fees. That's part of business. Yeah, I mean, if you get into a dispute, there's attorney fees. I mean, come on. I don't see why we're really debating that here right now. I think what we're debating is the town manager's responsibility in this, and I just don't see how the town manager would have any connectivity into these 2 trade publications through the JLMC process. I don't care how long he's been doing it. It just doesn't make any sense to me. And I also noted, I think, Ken, you brought it up last time about the town of Andover, but I did note that the town of Andover, after, following this for 3.5 years, just decided that there was really no culpability for Andrew Flanagan in this, and they pretty much have dropped it and walked away from it. I guess that's their decision, but that's where that ended up. I guess that's it. So net to me, again, we all have to go by the best guidance we get from our attorneys. The attorney certainly doesn't have the ability to go and find these two obscure publications and suddenly have those as his guiding documents. I mean, I understand, I've seen another opinion where there's attorneys that are very conservative in this process, and they feel that once the briefs are in and the discussions have occurred, they pull out and just say, let the briefs stand where they are. And I certainly respect that approach. But it seems like the majority of the cases that are being argued in front of the JLMC are not done that way. So again, we're coming back to conventions, not law, not policy, conventions. And I think we have to leave it at that, so.
Well, I'm not arguing that the money spent on the attorneys. You have to
Yeah.
defend. I agree with you. I mean, it is what it is.
Yeah, it is.
I went back to the testimony given where, on a few different occasions, Paul questioned whether this was being done properly. So clearly he was uneasy with it. As far as there are conservative attorneys out there, almost every attorney I talked to said, I wouldn't have done it that way personally. And I'm not aware of anybody who has done it that way. And even in the testimony by Mark Terry, he can only remember one other time he did it this way. And he wouldn't obviously mention a case because that opens him up for whatever the case
Yep,
was.
I saw that.
And the other 3 negotiations that it was 3, right, Paul, that he had been through with you and was Flanagan also on all 3 of those?
Yeah, 2 others, yeah.
Yeah. It didn't go on. So,
Well, I just go by also what our own attorney for union negotiations, Brian Mazur, has also mentioned, in that he said basically the rule is there are no rules, and we try to do whatever we can to negotiate these things. And as I keep going back and reading what I've read and talking to folks that I've been in touch with, I just don't see it. I don't see any reason to go forward with a disciplinary hearing at all.
so in business, if you had received an email from somebody that had come to them confidentially and then forwarded to you,
Well, why didn't I read that Ms. Wolfson forwarded or sent out an email and copied Paul on it directly?
No,
Was that not the case? Did I not read that?
no.
no, she
Okay.
did not.
Well, again, like when I saw a certain email that came out to all of us recently that said attorney-client privilege, I know what that means.
Right, you don't
okay?
forward it to anybody.
When I just see, of course not. When I just see confidential, I don't know what it's confidential to or to whom.
Well, remind me never to send you an email confidential.
Well, don't, Ben.
I mean,
Don't bother.
And that's not a personal knock, but like, I get confidential emails all the time. I know those aren't to be shared.
Yep, I had a top secret clearance before. I know what confidentiality is, and I've also worked in a public company, and I know what confidentiality is because SEC requires it. So I'm really pretty sure I've got a lot of background in that area.
Mark, you just said that confidential could mean, it means confidential
To whom?
to the person who receives it.
Okay, and if they feel as though the process is open to negotiation because that's the
And you said, do you
convention that
mind
was
if I
employed.
forward this on?
Okay, I've already stated what I had to state, Ken, and I'm not backing off of it. So if you want to argue, we can waste some more time. I've read everything, and I've made my opinion known. And don't bother sending me anything confidential if you don't feel comfortable with it.
So, and I mentioned this last time, the thing that I struggle with, I've gone back through your statement, Paul, and I do think that some of the excerpts taken were selective or not balanced in the total context. I also made a note about the confidential email. So my understanding of the communicating and the interacting with the parties from the members of the tripartite panel was that it is when the neutral arbitrator says it's time to go do that. And the confidential email, I believe, that was shared was the draft opinion of the neutral arbitrator asking for feedback from the other two panel members. So I was kind of left with the same question as when that lands in our hands, do we question that? I had also picked up on you cited a lot of Andrew Flanagan's testimony, but there was also testimony that there was a meeting after one of the sessions. He had copied you, I think, on one email. Mark Terry had asked him to go talk directly to you when Mark was not available. So I don't know, for me, that it's like so clear cut that there was this big distance. And like I said last time, I don't know of any attorney that doesn't act without the full knowledge of the client of what they're doing. And then, it's just things like the phone calls on the invoices. So Mark Terry called Andrew Flanagan and called you on the same thing, whatever that was. You also cited some things from the Attorney Harrington minutes, but like one of the things Attorney Harrington told us in one of his report outs was that when it comes to the town manager and other individuals, the discernment on credibility is really in the hands of the hearing officer, who is hearing the testimony, witnessing the visual, and putting the whole thing together in their evaluation of all the testimony and what they were exposed to. And then there was specific testimony about the town meeting bringing into question, when some town meeting reps were asking questions, should more have been disclosed about the background of how we got here. So I'm struggling with this. I don't feel that there's a drastic action that's warranted, but I still question the fundamental, did we know that we were doing something that was questionable? And that's kind of where I'm at. And I don't know, Attorney Fair, if you can help lend some light to any of this or look at specific things that people are concerned about, or where the board wants to take this now. And I also did go through the minutes again. That was one other thing for one of the sets of minutes that you cited from Attorney Harrington. In that same set of minutes, there's a comment that after his interviews with you, he still didn't know whether the MOU had been signed, and we clarified for him in the meeting that it had been. And in fact, I pulled it out of this book during that meeting to show him. So it's kind of where I go back to, I think we have to look at the total picture and not just selective excerpts. And I appreciate the time that was put into this, and I see the merits in some of it, but I also don't feel that it lays out the whole picture. So now what?
Well, I guess, in fairness to Mr. Cohen, I don't know if there's anything he wanted to respond to that. We should at least give him that opportunity. Aside from that, you know, as I said last time, the decision for the board to make, at least initially, is whether or not it believes is sufficient basis to schedule a disciplinary hearing. And then if so, what are we focusing that disciplinary hearing on? You know, we have to kind of identify, at least generally speaking, you know, what are the issues that would be the subjects of that. It can't just be the DLR decision. It's much too broad. It really doesn't define anything, and then certainly there's a lot of pieces of that I don't think you can attribute to the town manager. So that's essentially where the board's at.
Paul, do you want to say anything?
I mean, I think you've had the process backwards. All these things we cite and talk about, we've never talked about and had a discussion. I think if you had had the discussion, then you probably could have make an informed decision about whether to have a disciplinary hearing. We sit here and we pull excerpts. You accuse me of pulling excerpts out of context, but we have no discussion and dialogue over that. And I think that's where this has all been faulty from the very beginning. The day after the decision came out, I was told by you verbally, members want a disciplinary hearing. This was before the board even discussed.
I said members want a complaint discussion.
Exactly.
I did
right.
not say
Isn't that-
disciplinary
isn't that what
hearing.
you were
Want to discuss
discussing?
complaint, right.
That's
But
what
this
the-
was
that's
before
what
we
we're
even
here
discussed
for.
with the council whether to file an appeal and discuss the outcome of the case. And to this date, we've never had a discussion about some of these concerns that you're expressing. And so if we go to, please let me finish. So if we go to a disciplinary hearing, I'm just not sure it's going to happen there either. And I guess, and I've heard repeatedly this morning, well, none of these are serious breaches. And I hear concerns about legal expenditures and exhaustion of the town's time and effort, but yet we keep prolonging it. Haven't we done enough on this thing? Or, if you want to have further understanding, then let's have a discussion and dialogue on it. I'm willing to do that. Because quite frankly, I don't believe there was a document ever sent to me that said confidential. There was a document sent to Mark Terry that was marked confidential. It never made it to me. And I don't know, again, because we've never sat here and said, hey, Paul, on page 71, this is what said. We've never done that stuff. And I don't know if we want to go through that time and effort to do that. And to sit here and say, well, you're taking selective context, I just don't believe that's what I did. I don't think I was misleading with my report. What I was saying was, on first impression, for example, this is what Brian Harrington said, the first meeting with the board. That's how business is done at the JLMC. I think that's relevant. And yes, George Driscoll said, hey, you're right, I wouldn't have done it that way, the JLMC management rep. But he went on to say, as I quoted from him, there's no rules and procedures. So whether he would have done it that way, to me, is not relevant. The question of relevance is, were there rules and procedures at JLMC? And he answered the question was, no, there aren't. That's what's relevant about his conversation, not whether he would have done it that way. But we had Attorney Terry saying he had done it that way, and he knew of others who did it that way. And again, the other thing that goes up my backside is I cost the town $250,000. We didn't have to get to this point, and I said that the last time. Mm-hmm. I made repeated efforts to settle this thing early on, and we were rebuffed at every turn of the table, to the point where, as I've quoted from minutes and everything else, we offered the deal and the settlement, and even beyond that.
Oh,
But
you
to
and
sit-
I
but
had,
no, please let me finish. But yet it's sort of like that burden's on you. And then again, it's out of context. You're talking a one-time expenditure of $250,000. Do you know what 1% costs this town in salaries for the unions? $500,000 perpetually. So when people sit here and make, throw these talking points out there, you cost the town $250,000. Well, yeah, because I'm trying to fight to withhold the board's guidelines in the community, because these things roll forward and cost the town $500,000, $1 million annually. And we saw that in subsequent negotiations from previous decisions, where the unions received additional compensation beyond the guidelines because they cited the previous award in other cases. That has to all be considered. And I think that's what I fall upon you is, it's very clear that the JLMC, we've all said it, it's a murky water. But what are we trying to do here? What are we trying to do? What is the objective? Is the objective to have a clear understanding of what transpired? Or is the objective to just keep, rolling through this?
Well, Paul, the title of this meeting is discussion.
Right.
But we came to the last meeting and had a 37-minute, 10-page transmission from you that we couldn't respond to in real time. We wanted people wanted time to go look at that and digest it, and so now we're here at step 2, and the title of this meeting is still discussion.
So then let's have a discussion.
Well,
then.
I don't like the accusation that we're not having a discussion, because that is the whole point of the last meeting and this meeting.
And we did follow the process. We had a meeting to talk about an appeal or not. And after that meeting, is my understanding, that's when I voiced concerns about having this meeting, which is a discussion to vet. And that's my understanding of the process, is then you opted to have it in public session, which obviously then puts everybody back in their seats and not speaking as freely as if we were in behind closed doors. So,
Well, first of all, as I said earlier,
And those were, I'm sorry,
I-
but those are two separate meetings, okay? The meeting that you referred to, that we had to talk about the decision, had nothing to do with this. That was, what are we doing with the decision?
right, but you would
So
inform me
there-
about this prior to having that
Well, I had
meeting.
received
Right,
I had received at
exactly.
least one phone call by that time, and I was giving you a courtesy heads up.
Exactly.
And then,
Right. So my point is, let's have a discussion if we want to have a discussion. But instead, what we're doing is we're making statements and we're citing things, but we're not having a back and forth and exchange. Again, if the concern is, hey, you received confidential documents, show me the evidence and let's discuss where it is that I received confidential documents. Because in my recollection, I don't remember receiving anything that was stamped confidential. As I said earlier, for example, Attorney Terry received the draft decision. I didn't. That was the thing that was marked confidential. I didn't receive it. And if we want to talk about the town meeting, let's put the video up of the town meeting and show me where I misled the town meeting. And the idea that I can interject, we were just at town meeting, we're going to go to town meeting next week, and we've been at repeated town meetings. When your presentation is done at the podium, it's not to sit there and engage in debate every point or by the presenters in the middle of the room who are making their statements. That's been made clear to me over the years. That's not what we're there to do. You're there to make your presentation, and you're there at the podium to answer questions. And then when the questions are done and answered, you go away. You're not, the presenter is not there to debate the comments and statements of the audience. And that's on this matter or any other matter. So to suggest that I should have, leaped up to the podium and said, hey, whoa, I just don't think it's accurate. As I said, it didn't cross my mind because I didn't know that what had transpired was improper or illegal. Had somebody asked at town meeting, hey, town manager, who drafted this award, I would have answered it. Well, where did this come from? I would have answered it. That question was never asked. It was never suggested. As I've stated earlier, I didn't reference the dissent in my presentation. That was done unbeknownst to me by the Finance Committee. And so, again, I don't know what I can be held accountable for other than my own behavior. And I think that's hopefully what this is trying to get at is not what did the town decide, what is it that
Paul,
I did?
help me with your last statement.
Sure.
About unbeknownst by you, by the finance committee, they got the dissent from you.
Well, no, well, yes.
I know your
and
presentation
you got the
didn't
dissent.
reference
You
it
got the
because you
dissent from. You
support
got
it.
the select board got the dissent from me as well. It was
Well, I
part of the.
wasn't
It was
on
part
the
of. It
board
was
at
part of the
that time.
JLMC materials that were distributed that afternoon. I forwarded it to the finance committee and the select board, and it was signed by Andrew Flanagan. So yes, of course they got it from me because that was the package that was delivered to me from Attorney Terry. It was the award and the dissent. So yes, I forwarded it to the finance committee. But as I think the record is clear, I didn't discuss it with the finance committee. I didn't outreach to anybody on the finance committee or otherwise, and I didn't present it at town meeting. I presented the award, and as I said at the time, I expected to leave that night town meeting with the award funded. And if you go back into the transcript and discussion, the reason that Attorney Terry explained for the dissent was he wanted that document to assist the town in subsequent negotiations. That's what the dissent was about. It wasn't to defeat the award at town meeting. And as I think, even as I read this morning, if I wanted to not, we could have easily have tabled it, said, hey, again, I'm the one who puts the article on the warrant for the chicken special town meeting as a placeholder, and I'm fighting to get this decision so that we can get the thing resolved and move forward. I just think, again, you talk about looking at the totality of the actions. Look at the totality of my actions.
Well, I
And
think
and
that's
these
what it comes
notions,
down
and,
to,
yeah,
is
and these
your
notions about that I acted secretly or show me where it was that I hid something. I'm sick of hearing that word. You hid information. Show me what it is that I hid. Again, I certainly didn't. Certainly didn't ask Attorney Terry to hide it on his legal invoice. And you know as well as I do, we have
Said,
very
well,
vague
who-
legal
who at
invoices.
this table said you hid something?
The clerk of the board said that that materials that my actions were done in hidden manner.
Okay.
I mean, I think Paul makes, his point is, this comes down to his mindset and what he believed, and as you go through this, I can't, like you said, we can't really hold or care about what Attorney Terry did or said or maneuvered or what Andrew Flanagan did or forwarded. And sure, I mean, if he did, I think I did read, you were forwarded it a confidential email. And I'm not saying you forwarded it. I'm saying that if you received. But it all goes back to your state of mind, Paul. You clearly, in your testimony, at a couple different points, said you had concerns about and were questioning why this was going on. That's all mine comes down to is if you were uneasy with it and you felt that this wasn't the right way to do it, why did it happen?
Do we have those? Do we have that testimony?
I gotta dig through it.
No, because I mean, I'd be helpful to see it because I'd like to fully understand what it is my statement was.
You're gonna have to give me a few minutes.
Paul, you and I met on a couple of occasions to help resolve this
Yeah.
situation. You and I one-on-one, and, and then later on, we got back because he had to recuse himself. He was the chair. Pat wasn't available or something, so they asked me to sit in with you, the chief, and the union people. And we come like this close to making it happen. So it's not like, I thought you were referring that we weren't trying to do anything to help you in the situation. And when I said the money, I mean, we spent all kinds of legal fees, and I was hoping we could have, and I thought we had it settled that money, to be truthful with you. Unfortunately, we didn't because this town is fractured. I mean, it really is, Paul. The people that were friends for years don't speak to each other anymore, and this guy's a bad guy, this guy's a bad guy, he said this, he did that. I mean, it's just sad, that's all, and we just gotta, get it all out on the table and come to a final decision and go forward. And that's, and that's what we were trying to do in the very beginning. Let's find a happy end, let's get it over with, instead of 6 years of, And I can understand the people on the other side being upset, and I can understand, you have a job to do. I get all that stuff. But I don't know. I just... I was concerned even with you, I even said to you, Paul, what do you want to put your family through this, right? Did I say that to you? You remember that?
Right.
I said, what do you want to put all this stuff, you know, and you say, that's why when I mentioned money, I mean, we were talking at that time, and then you said to me, it's only a one-time deal, as opposed to, and I understood what you meant, you know, it's business. I mean, you have a good business head, but, I mean, we had those discussions. So, I mean, I don't want people to think that we weren't trying to help you and the whole situation at the time.
Excuse me, your voice is Carrie, so could you take it in the hallway, please? Thank you.
I don't want to go there. So that's all I'm trying to say. I mean, you know, and that's why I think if we get squared away and
So I guess the question I'd have is, if we have a disciplinary hearing, what more is going to come out? And what more will transpire that will enlighten the board or the community? Because I guess I just don't see what more to be covered, whether it's today's discussion or you move to a disciplinary hearing. What more is there to do and say and provide? And what will transpire there that's going to provide any benefit to the board or the community
well, it's
beyond
not
where
just
we
the
are?
board. I think it's the whole town as a whole. It's the town as a whole. It's the people out there that are, they don't know where we're at. They don't know, you know, who did what. I mean, you know, it might be the best thing that ever happened. We did it, and everything gets put out there, and everybody at least understood what happened, including some of
But
us.
at this point, George, everything's out there.
Yeah.
I mean, if someone wanted to sit down and
Yeah,
read
but
through it.
in different ways, though, Ken. You know what I mean? It depends who you listen to.
Yeah, but
Well,
that's,
yeah,
nobody's
that's-
going to change that.
Yeah, right.
People are going to
Yeah.
believe what they want to believe and listen.
Well, it's just like here. I mean, everybody sees the excerpts that,
Exactly.
you know, speak to them. And so they refer to those. And we can sit here and do that for 4 more hours, and we're still not going to get anywhere. This is a gray process. It's fluid process, and it's very difficult to pin something down, black and white. Here's the silver bullet, and this is it. It's just not going to happen that way.
So, Paul, I'd have to
Do
dig through stacks of these, but I did find one quick example. Right, and so this was on, I forget the day of the testimony, but I can give it to you. The question to you was, all right, sorry, this is the first time I've heard any of this, so prior to the dissent being written, Attorney Terry asked you for authority to go ahead and to participate in this endeavor, correct? And your answer was, what Attorney Terry asked me was for him to draft the dissent. I was not involved in the decision on whether to do a dissent. Question, all right, you questioned him, why are you doing this? You said, that's correct. I wondered why wasn't Andrew Flanagan doing this? Question, you thought this unusual? Yes. Question, all right. And his response to you was, Mr. Flanagan's busy. Is that right? Yeah, I explained he didn't have time to formally draft the dissent. Therefore, he asked my permission to draft it, and I agreed. So, I mean, clearly you were questioning why wasn't Flanagan doing it, and why am I paying the town manager, and is this a normal procedure? So I mean, you had some reservation as you went through this.
But that doesn't imply that what I thought was going on was illegal or unethical. That's not what I'm saying. What my question was is, why isn't Andrew Flanagan doing this? That's his job as a management rep. That's clearly, it's done in cross-examination as well as direct testimony. The conclusion I have is, either he was busy or he was lazy. It's one of those two. And I knew the decision was going to be issued on that Monday. But again, yes, I did question that because I think anybody would ask that question. Well, why, and I asked it. But it wasn't conveyed to me that, oh, well, this is a violation of law or of JLMC rule or it's unethical or questionable. My question was, why is council doing it, and i.e. the town paying for this?
And then when
The answer was it was busy.
Right.
Oh, okay.
And then when it was
I get
written,
it's a weekend.
right.
It's a Saturday. The decision's coming out on Monday. He wants to get something in at the end of the record because the decision's coming down, and as I said earlier, they wanted something to help with subsequent negotiations.
And
But
so you didn't proof the dissent.
no, he did. He did send it to me.
He did.
I
He
did,
did
and
read it.
I readily admitted that. I looked at it and said, yeah, this seems fine. The math. There was a math exercise about the 1% versus over 3 years versus 3% in the last year. I said, yeah, that's accurate. Fine. Again, I didn't have the understanding that was unethical, illegal, violated any rules or procedure. So no, I didn't submit any edits. No. Again, we're not trying to retry the case, but I think, as I said at the time, yeah, I saw it. I admit it. I did see it. didn't do anything with it other than read it and say, yeah, this is fine. And again, as I said,
Yeah, but reading it and approving it is an edit, in theory.
But I expected that Flanagan, if he had any issues with it, as I testified, and my mindset was, this was based on the discussions that Andrew Flanagan had with Mark Terry over the times from, up to that point in time. My sense was, if Andrew Flanagan had any concerns with it, he would make modifications and then submit it. But I think we saw repeatedly in the testimony, Flanagan often just forwarded whatever Attorney Terry gave him, which we learned afterwards, but I didn't know that the case at the time. But again, I don't think that shows that I did anything that was violated any law, rule, or procedure, that I should be knowing of or be reasonable to be held accountable for.
You didn't
we're
tell
not
him
gonna
you thought it was
dispute.
a bad idea, though. I mean, you
No, I question why are we paying counsel $200 an hour to write the decision that
That's
Flanagan should be
what I
doing?
Took from that.
That's my
We
opinion.
paying for it, the draft,
And again, if it was something surreptitious, then I would have said, hey, well, make sure you don't put that in the bill, or if you put it in the bill, put it in kind of vaguely about, none of that transpired. Because again, there's no conspiracy, or there's no cover up. It's just, okay, we've come to the end of the road. Just let's finish it off, be done with it. If Andrew's not available and you've got to get this dissent in on Monday morning and it's Saturday, yeah, just do it. And he says, I'll send it to you. Fine. I looked at it. That's fine. Yeah, again, I'm not retracting or disputing any of that, but I think it's a leap of that's in a that to then say, oh well, you knowingly participated in something that was unlawful or and unethical and violated the rules, and therefore you misled the town meeting and the finance committee. I don't think that's a reasonable outcome from that citation, or from that that action that took place.
I got to find the other ones, because there were times where you asked, were you uneasy with this, and you said yes.
Yeah, if that's what you characterize uneasy, yeah, I'm uneasy. Why is
No,
why
there
are
were
we
other
paying?
comments where
Right,
they
no,
asked
but I'm just
about-
giving you in this
yeah.
example. Why are we paying Attorney Terry to do Andrew Flanagan's work? I would hope you want me to be uneasy with that stuff.
So does it make sense to get all the specific excerpts together and
So,
come
look,
back and?
Joe, what's the
and
pro-
Go ahead.
process?
Well, I have a second question, is if the board were to go to a disciplinary hearing, what are the disciplinary options? But go ahead, Kim, what was your question?
Well, to be clear, so, from what the comments Paul made, we're doing this out of order. My understanding is we're following exactly the way the rules are written. You meet, you vote to either appeal the decision or not. Then after that was done, or probably that morning, I think I said something to Virginia, like, as I'm reading this stuff, I'm not comfortable, like, I want to know what exactly, and that's probably why she gave Paul the heads up. Then you let him know, are we out of process here?
No, in my opinion, this is the process. Under the open meeting law, the board can't have a discussion outside of a meeting. So the board has to schedule a meeting to consider what, if anything, whether or not the events that transpired rise to the level of even needing a disciplinary hearing, which is why we schedule these meetings. Now, how the board utilizes that process, I don't necessarily control, but to Mr. Cohen's point, if there's uncertainty as to what happened and transpired and the board needs more information, this is what this forum is for, is to have that discussion, to go through the information, to get answers to questions that the board may have, and so that's the process. And then once you make a determination as a board that there's something here for us to move forward on, then you would schedule an actual disciplinary hearing and identify what it is that we're actually holding the hearing on. So I think the process is correct, but having, identifying what you're basing it on and having that discussion, I think in the prior meeting was more or less just reading statements, as Mr. Cohen, noted, and today's been a little bit more of pointing to pieces in the record as to where the support lies. But it's ultimately a call for the board to make, whether or not you feel there's sufficient information here to move forward with a disciplinary hearing.
And then the step in the disciplinary hearing, is it more discussion or just this is what the charge is and what's the discipline?
Well, typically, so in a disciplinary case, the employer has the burden of showing that there was a sufficient basis, sufficient evidence to warrant disciplining the employee. So the initial burden is really on the town, the board in this case, to say, well, here is what we believe the misconduct is, and here is the evidentiary support for that. That gets presented, and then at that point, the employee has an opportunity to respond and present, whatever defense or countervailing evidence he may have. But it's really initially at a disciplinary hearing incumbent upon the board to say why this is worthy of discipline and what the evidentiary support for that is.
And then when you're in the disciplinary hearing stage and you hear what the charge is and the employee defends, the employer then decides to go forward with punishment, and if so, what the level of punishment is?
Correct.
And then the employee does what? Accepts it or appeals it or?
Well, I suppose it depends. I mean, it's up to the employee, and it depends on what the action is that's taken. I mean, there's different options. We're kind of, it's hard to answer it, generally without knowing the particulars of whatever transpired, in advance.
Is it fair to say that one of them could be legal?
I guess depending on the action, sure. I mean,
So there could be legal ramifications coming back.
well, anytime there's an action taken against an employee, there's always that potential,
Right.
sure.
So, Ken, did you want time to pull out the specific evidentiary excerpts
Well, I mean,
to talk about, or
Would you do that here or would you do that in the hearing phase?
or continuation of this, or in a hearing phase?
It's really entirely up to the board. I mean, typically when you're walking into a disciplinary hearing, you should already have a sense of what your evidence is that you're relying upon to support the disciplinary action, but it's not as if it has to all be assembled in advance. Oftentimes that gets presented at the hearing. You do at least need in advance to have an idea that there is sufficient evidence to go forward, even if you haven't identified every single piece of it, and that there's sufficient evidence to warrant going forward and having a disciplinary hearing on, whatever it is that you're holding the hearing on. Conversely, if someone wanted to be more exacting and make sure before we schedule a disciplinary hearing and go down that road that there is enough, you could certainly do it that way as well. I have to say, it's a little bit unusual when you have, it's difficult, I should say, when you have boards of selectmen that are the appointing authority, right? Because typically, when an employee would be a town manager, let's say the town manager, there's an investigation done, they gather all the facts, and then you're making decisions. And if that's all happening behind the scenes, can happen, you can gather it as you go. Unfortunately, because of the open meeting law, and we're dealing with a board here, everything has to happen in this space. So it makes it a little bit more clunky and cumbersome, but that is the process. Other than that, there's really no way for the board to, review these matters short of, hiring somebody to do an investigation for the board, which in a case like this, I don't know that would have been warranted.
I mean,
So do you-
I don't know how you want to proceed as a board. I know that, again, I have to go through. I tried to print off everything, but I didn't clearly mark and highlight to flip right to those sections. I didn't think we were going to get into that today.
Well,
I thought that was
that's
the
why
next
I'm
step, but-
asking, because I don't want to spend another 2 hours to research and go through stuff in real time here. So do we reconvene to go through the details?
That's up to you. I mean, from what he just said, we can go to the next stage and at that point, come up with the details, or, I mean, I do know, and again, you know, Paul speaks to his mindset on what he says in these minutes, but I didn't read it that way. I don't interpret it that way. But we could argue that all day long, you know, but that's one interpretation, that's my and there was another point where he was asked, were you uncomfortable with this? Yes. So, and I know he you know, the confidential email was shared with him. I don't think he forwarded it, but he did receive it. So I do feel he knew what was going on was not kosher, or should have known it wasn't kosher.
Being uncomfortable, though, doesn't mean necessarily that he felt it wasn't kosher or that it was unlawful. He was just uncomfortable with something potentially that he just didn't fully understand, didn't fully know what the basis was for it. That's how, I mean, that's another interpretation of being uncomfortable. And
Okay,
then the other
so
question.
should he have known it?
Well, I've already made my statement on that. I don't think so. But I also, you know, just a really back question, not getting into the disciplinary side, but if you were to look at corrective action as a board for this outside of discipline, would you change the policy that we have in town to say that there's no communication allowed by the town manager after briefs and arbitration hearings been completed? Because the JLMC is not going to do that for you. And if that's how you really feel, is that something that we would do? I mean, do we feel that that's what should occur here? I'm just
And
curious.
I'm with you on that, Mark, because I also looked to see if the JLMC changed their, they've
Not
done
that I
nothing.
saw. They've done
So-
nothing. No,
so
I know.
clearly, they're not.
So if we don't do it, and if we don't feel strongly about it, what are we doing here? It's my logic.
You know, quite frankly, I think the town and the town manager and this board, we've already taken a reputational hit based on the DLR decision. And quite frankly, I think if there's any punishment, that is sufficient. What we've already encountered and what we get from the townspeople, as everybody said. I mean, everybody has an opinion about this one way or the other.
Right, but we are a policy-making board, so should we change our policy?
I mean, I think that's a
You know,
different
what do you think?
discussion, but I don't think so. I
Okay.
don't think so.
Well, that's what I'm asking, you know? What
I
everybody's
don't
thoughts
necessarily know
are.
if you change your policy, but maybe you demand a,
Well, this is black and white. That's why I'm trying to, you know, is that the approach that we want to take?
it is. I mean, I hear what you're saying, Mark, but this wasn't, I don't think it was as common practice as they were making it seem. Every attorney I've talked to on this topic, including Joe, said it's not something they would have done and not something they'd ever done. So, you know, these gray lines get pushed and pushed and pushed until someone steps over. When someone steps over, that's what makes law. And I'm not looking to make law here, but I do think we walked over a line in the negotiation process that gave us a slightly unfair advantage that shouldn't have been walked over.
No, but as you said, the JLMC doesn't feel strong enough about it to make any changes in their rules. You know, that's,
Joe wants to say something.
I just want to clarify something, just for the record, since Mr. Lefebvre just made a reference to something that I've said. I do want to distinguish between sort of what I, you know, as a practicing labor attorney for, you know, I don't know, 25 years or so, what I would do or not do is more of a comparison to Mr. Terry, because he would be sort of playing, I would be playing his role in that situation. That's what I would do from a personal standpoint, but that I would not go so far as to say that that's because I know that there's a JLMC provision or rule or prohibition against that. You know, consistent with what has been said at this meeting, the JLMC process has always historically been very gray when it gets into the stage between mediation, where the panel members are sitting in your room in your discussions and advocating, notwithstanding what the DLR hearing officer may have concluded, but they are in effect advocating. I've witnessed it myself. And when then the matter proceeds to arbitration, you know, what is their role supposed to be in that? Are they suddenly neutrals, or do they continue to be advocates? That has always been a very gray area. So again, because of that grayness, maybe I'm risk averse.
Right.
My preference is I would not have done that, but I don't want that to be mistaken as a reflection of what that correlates what the town manager should or should not have done, because he's one step removed from me, and Mark Terry would really be playing my role in that analysis. I just want to
I
make
didn't
sure
mean to
that.
infer
Yeah.
that.
Yeah,
Yeah,
no,
that's
I know,
exactly-
but I know you know that, but I wanted to make
Yeah.
sure.
No,
you
that's
know,
exactly
so-
how I understood
Okay.
your position.
And Selectman LaFave, to your point, I don't think there's evidence, and I know it was for the fact, I'm not pushing that boundary line, right? It's very clear from the decision and the testimony, the ex parte communication was initiated by Andrew Flanagan to Mark Terry. It's very clear from the testimony and the decision, the dissent issue was raised by Attorney Terry to Andrew Flanagan. So if anybody was pushing the boundaries, it certainly wasn't me. And this is a disciplinary hearing or discussion about me and my actions.
Right.
So I guess the question is if you're concerned about, pushing this line, everything else, and looking at the totality,
So-
it's
so
not
aside
me.
from
I'm
them-
not pushing the line. I'm not pushing the boundary.
Right. But aside from, were you comfortable with this whole proceeding?
At the time I was. I didn't realize that anything was taking place was unethical or illegal or violated any rules. So yes, my conversations and mindset with Attorney Terry was, this is how he's doing his business and how he conducts himself and is representing the town of the JLMC. You know, and again, remember, I don't have much experience with him either. Because the board had changed counsel and appointed, Myrick O'Connell and Attorney Terry as the town's labor counsel. So, so to me, and again, the one thing I've stated and it's been said here this morning, every arbitration decision is handled differently. So therefore, I wasn't of the sense of, wait a minute, what's going on here? No, I'm like, okay, as was just stated, the process is driven by, at the arbitration season, by the attorney for the town. So again, Ken, I'm sort of in amazement, of participating to the best of my ability to represent the town and to achieve an outcome that benefits the town, yes. But it never occurred to me that what was taking place was unethical, illegal, or improper.
So I guess we have to go back and dig through it then.
Come back to this forum.
I mean, I don't sense that there's enough people here that want to move forward with the hearing.
My sense is whether it's this meeting continued or a hearing, what I'm hearing from Joe is we need the details of the specific testimony or evidence or whatever we're bringing forward. Is that?
Carol, excuse me. How much more specific do you have to be than what the hearing officer, what the verdicts were,
Well,
outcomes or whatever you want?
so one of the things that you'll note in the decision, it's in a footnote, but the issue where a question was raised, it's page 34, footnote 26, talking about the town and the union dispute the extent to which a town manager participated in the unlawful conduct or had knowledge of town council's conduct. And then the footnote basically says that the town, as an entity, is responsible for the actions of its employees and agents. So, you can't just rely on this and say that the town manager did something unlawful, because a lot of the activity that was taking place, or the actions or inactions, were taken by Mark Terry in connection with his representation of the town. So even if the town manager was completely in the dark on everything, the same decision could have issued because of the actions that, against the town, because Terry was serving as an agent of the town. So you can't really just say, point to this. You really have to narrow it down to specifically what is the town manager's role in this, and what is he culpable for. If I could make a suggestion at this point, because I know the board's been kind of going back and forth, and what is the process and our process. I think while you can go forward with a disciplinary hearing without having this all vetted out, it seems that there's enough here of an ambiguity as to, what the town manager knew or didn't know at the time, or what he felt, that perhaps the board should take a little bit longer look as to what it is that you feel support going forward. Because if you schedule the hearing, you're going to have to do it there anyway. But I'm not sure you schedule a disciplinary hearing now, and you're not in a situation where you even have a full sense of what it is we're going to point to justify it. Because you may conclude in the end, you're going to have a disciplinary hearing, and in the end you say, well, there may not be enough there. And so you've kind of taken another step without really needing to. So,
And I guess that was the basis for my question, because I feel if there are still questions on the table, we should get that clarified. And I don't know whether, that was my question, was do you move to a disciplinary hearing to get that clarified, or do you continue this discussion and give the board members more time
so
to get it clarified and get it codified, I guess is probably a better word.
yeah. So while technically speaking, it doesn't have to be, if you feel you have enough. It's sort of like the difference between,
Right.
in a criminal setting, you have probable cause, doesn't mean you have enough evidence to convict, right? You can go forward to the trial. However, normally, and this is where the open meeting law puts you folks at a disadvantage, is there's no real investigation that's been conducted fully to go through everything from your standpoint. So I guess my suggestion would be, having listened to everyone and hearing that folks still have some questions, you'd be better served resolving those questions in advance rather than trying to resolve them at an actual disciplinary hearing. That would be my suggestion at this point.
Okay. Ken and George, are you okay with that? Yeah. So should we pick another day?
Would it be helpful we waited to see if the other decision came down? I mean, so we could get everything out of the way at one time? If there is anything else? I'm just asking the question. I mean, this isn't a...
I don't know if they're interrelated. Say again?
I thought that's a good question. Yeah.
Is it?
I mean, my concern is, I have a lot of concerns. My biggest concern is the town of Chelmsford, to be very honest with you. And it is fractured, and there's a lot of, and it's, whoever's to blame, we don't know, but I'd like to see most of the people satisfied. You can't walk down the street without somebody talking about it, one way or the other, taking this side or that side or whatever. I've lived here my whole life. I don't want to go into all that. I mean, we just I'd like to walk down the street and and show it everybody else here, probably, you know what I mean? Have a cup of coffee and not have to get in an argument with somebody over it, you know what I mean? So, what is the best way so that we can get the whole thing resolved?
I can't say that I didn't handle the other case, right? So I do understand there's another unfair labor practice charge case. I don't know the particulars of, the town manager's role in that, or what's being alleged to know whether or not there might be, if the town was found to have violated the law, how much of that falls back to the town manager individually. So it's a difficult question for me to answer, Mr. Dixon, but I guess I can answer it this way, though, is that if the board feels that there were, actions or inactions on the part of the town manager at issue in that case, that might put you right back in this same room, having the same kind of a discussion. You could defer further review of this matter until such time as that decision comes out, and decide whether you want to go forward or not at that point in time, depending on what that result is.
So the final briefs for that decision were submitted last September, 13 months ago. Do you have any sense for crystal ball?
No, I'm waiting for an arbitration award from the DLR that's older than that. So I wish I could predict, how quickly they turn those things around. It really depends on the particular hearing officer that handled the case, what their caseload is, however many decisions they have to write in front of it. By comparison, how long did it take you to get this decision? This was data issued.
14 months,
Briefs were submitted in June. Came out in September,
June of 22.
June of 21.
June of 21. Okay, so you're 15 months on that one, and you're at 13 months on this one? Well,
Months?
that would be at least some yardstick to measure by, yeah.
Is that your preference, George?
Well, I just throwing it out there I just want to get the thing
Yeah,
squared away.
Ken?
I don't want to go through this twice.
Would you rather wait?
I'd rather deal with the totality of the issues involved here.
I don't know. I just feel like we've gone a long way down the road now, and I
Yeah,
didn't even think about the other one.
Yeah, and the problem is, it just keeps everything up in the air too. But, I did ask you the question, but at the same time, maybe not rebutting it, but I'm.
Well, there's nothing that says that we couldn't, if you needed to boil down what you want to with regard to this particular topic, and then hold it until the other one is there, and then determine if there's anything that's actionable there, and then make a decision from there. We could go that way too.
I think you could do it either way,
Yeah,
because
I think,
DLR separated them as two different cases.
But
I think to Mr. Carrada's point, though, is you don't have to, you could still make use of the time
Right.
that you're waiting for the DLR decision to come out by doing the sort of behind-the-scenes homework that we're talking about the board doing.
That makes sense.
And then
Yeah.
hold for the time being, rescheduling this matter,
Right.
allow some additional time to pass to see what the DLR does. And if the board at some point decides, we're 3 months down the road and we still haven't heard anything from the DLR, you could decide to put this back on if that's what you wish to do. But in the meantime, you may get a DLR decision, and then you can go from there and see what that decision reads. I'm not as familiar with the facts of that one, so I don't know how that decision might interplay with this one.
Ken, what did you say?
Well, I agree with what Attorney Fair just said. At least we can hone down our argument and get it prepared. And if a few weeks goes by and nothing happens, then we can move forward with the hearing or the next meeting.
Do we
to look
want
at the
to,
hearing.
do we want to set a time frame where we meet, if the next decision doesn't come out, we want to meet by a certain time frame?
So what was your calculation, 2 more months?
Yeah, I would, that's generous to say my calculation. I was just using however long it took you to get this most recent decision. You're about 2 months to go from when the briefs were filed in the current case you're waiting on. Whether that's a calculation or not.
If I'm being asked
So
to go back and sharpen my, spruce my evidence up, right, and go through and make my argument, that's fair. I'll go back and do that, and if in a week I send an email and say, I'm ready to go. It's up to you guys when you want to go. You tell me what you want to do.
You said in a week?
I mean, it's not going to take me long to go back through and find all my notes and put them back together. So,
Yeah, but if we're gonna
Right,
wait for,
I'm asking if you have a preference to push this one forward or to say we're gonna meet in 2 months regardless of whether the other ones come out.
I know, but then when you get to 2 months, you're like, well, we should be getting it any day. Let's wait another
Right,
week.
right.
I mean, that's a,
I'm sorry,
you-
Pat, what were you saying?
yeah, I mean, both George and Mark kind of indicated to wait until we get that, and I think we should give it more than a week.
Yeah, my opinion is once you have everything together, okay, at some point, whether that's 2 weeks or whatever, maybe we should meet, just review what you do have, and then decide from that whether we should proceed forward or hold.
That would make more sense.
And that's what I would recommend.
Does that
fair
work?
enough. Yep.
And then
That way it stays
we're not
fresh.
just indefinitely delaying. Can we pick a time?
Your town meeting, what, next week or a week?
Mark was suggesting a couple weeks out. Is that enough time?
I'm out of town a part of the week of the 24th.
When would you like to?
I mean, my schedule's probably the easiest to manage out of.
So
I know,
early-
but you're the one that has to probably do the most prep work.
I don't know. Yeah, I mean, you could go the week of the 31st,
Week of the 31st, is that okay?
not Monday night.
Would you say the 31st, you want to do it?
Not Monday night.
Okay, good.
I don't think you do either.
Say no.
Not with the granddaughter.
What do people have Tuesday the 1st?
It's fine.
That one wouldn't work for me.
That won't work? What works, Joe?
Second, third, or fourth, be fine. Particularly, the afternoon's wide open. But it depends. Are you looking morning, evening, afternoon?
The 2nd, I'm open from 10 o'clock on, unless there's really a ribbon cutting that day that you have to be at, Paul, or could somebody else cover that?
I can't do the 2nd, so just so you know.
The third?
The 3rd, it would have to be later in the afternoon for me. I have an inflexible medical appointment at 12:30.
So like 3 o'clock or something like that?
I could do that on the 3rd.
That's a Thursday?
Thursday the third?
We pay you for travel time.
Yes.
So let's get them up Route 3 before 2:30.
3 o'clock on the 3rd.
That'll work.
Does that work for you, George? Paul, does that work for you?
Yes, that's fine.
Okay. If there's no more discussion, it's 10:44.
I'll make a motion to adjourn.
Second.
All those in favor? Oh,
Aye.
yeah, Republic, aye.
Thanks, Joe.
Thank you, Joe.